announcements. And first, just want to begin by saying welcome to all of you. As typically is the case, we have a good mix of regulars and first-time attendees. So if this is your first time at a Central Ohio Labor and Employment Relations Association meeting, we are very glad to have you and encourage you to become a member of COLERA. And for those of you who have been with us before, welcome back. Always glad to have you with us. First thing I want to share with everybody is some exciting news. And I want to give a special thank you, as always, to Emily Smith and Bernadette Tiemann, who are helping to facilitate our virtual sessions from our national office. They are both with the National Labor and Employment Relations Association, headquartered in Illinois.
I apologize. I don't know if you can hear me, but I've frozen and unfrozen. So I'm not sure if I'm coming across to you.
I hear you, but your video is frozen. You might want to turn your video off and on. And actually, it looks like you're okay now.
Okay, good. Yeah, I'm sorry. I was in and out, so I didn't know what was going on.
No, that's okay. We're just doing a couple announcements, and I'll kick it over to you in a couple minutes. Anyway, received news that that our Central Ohio chapter has been honored with a Star Chapter Award for 2021 for consistent chapter excellence, and this is a great honor. We're very excited about that. I sent a note to our board members earlier today, but just wanted to say to all of you members, whether you're on the board or you're a regular participant or this is your first time with us, you're the reason that we received that honor. We very much appreciate the support that we have from our national organization, but it's the grassroots participation, having a creative program schedule. And in fact, we've been able to turn the challenges of COVID into opportunities by taking advantage of technology in new ways. Not only have we offered a monthly program from September through May with topics of interest from a variety of perspectives, labor management neutral, on a whole host of policy issues and talking about labor and employment relations from many different perspectives. But we also were able to, with the support of the national organization, provide in a seminar series, a training program on virtual ADR, alternative dispute resolution, their A to Z program. And so being able to do that and really expand our program offerings in spite of COVID in some ways, as a result of this technology has been great. So thank you very much, Emily and Bernadette, for recognizing our chapter. Thank you to everybody who has been involved in COLERA this year and in the past, and hope that you will all continue to be involved. But we're excited looking ahead to next year, speaking of the boathouse, of figuring out how do we build on the opportunities that technology has provided to us while getting back, when it's safe, and hopefully it's we're getting closer and closer to that. In fact, I just saw that the case numbers are starting to drop again a little bit in the state of Ohio. So as more and more of us get vaccinated, as we get closer to some semblance of normalcy, getting back to the boathouse and figuring out a good blended way of continuing our program is something that we're going to want to do. So that's the first thing. Secondly, I just want to mention that our next and our final program for the 2020-2021 program year is going to be happening on May 18th. It is Tuesday, as always. But as we've done in the past, it's going to be a little bit different than our typical program. It's what I'm calling a triple feature. And we're going to begin at 2 o'clock in the afternoon as opposed to the normal lunchtime at noon. We begin with a presentation by Columbus City Councilwoman Elizabeth Brown on trends related to family leave and how family leave is expanding in policy and expanding in bargaining agreements. So she's going to share at 2 o'clock on the 18th. That'll be like a typical presentation. She'll present. There'll be an opportunity for engagement, question and answer, and so forth, and discussion. And then at 3:15, part 2 of our triple feature will be our ever popular arbitrator panel. Sandy Furman, Jerry Selman, and Robert Stein are going to share experiences from the past year on a variety of issues, including how it's been conducting virtual hearings, issues related to off-duty conduct, which has become a hot topic in arbitration. And of course, this is something that we've talked about in the past, social media and arbitrations related to people running into hot water related to social media use. But that panel is always very interesting, very engaging. That's going to, again, start at 3:15. And then we will have a brief general membership meeting at 4:30 to, among other things, but primarily to elect a slate of officers and board members for next year. I'm going to be stepping into the role of past president. We are excited about Mita Bass, our vice president, stepping up hopefully as president. Chris Hasselberger has graciously agreed to step into the role of vice president for next year. And of course, we've got the one and only Don Collins as our chapter treasurer, who we're counting on to continue in that role, and has always been a great leader in this organization from a variety of perspectives. So we have 4 seats on our board, 4 labor seats, 4 management seats, and 4 neutral seats. And, you know, if you are interested in serving on the COLERA board, if you're a current board member, want to hear if you're interested in serving, I hope you will continue to serve. But if we have any openings and you have not been a board member before, generally being on the board is not a time-consuming responsibility. We have 2 major committees. One is our program committee that plans our speakers for each month and other kinds of program opportunities. And then we have a membership committee that talks about how do we, you know, continue to build the level of participation in our chapter. So send me an email. I will put my email address in the chat. If you have an interest in serving on the board for next year, we will put together a slate, and then we'll be asking our membership to vote on that slate during the general membership meeting on May 18th. So that way we have our board ready to go to do planning over the summer for next year. So those are the things that are going on. I'll just pause to see if anybody has any questions, or if Don or Mita or anybody else has anything to add to those announcements, and then I'll get to introducing our featured speaker for today. All right. So seeing none, we are very fortunate today to have Stephen Carney, who is a Deputy Solicitor General in the Ohio Attorney General's office, with us today. He's in the appeals unit. He frequently briefs and argues cases in the Ohio Supreme Court, where he has argued over 40 cases and has briefed many more. He also briefs and argues in the U.S. Court of Appeals for the 6th Circuit and has written many briefs in the U.S. Supreme Court. His U.S. Supreme Court briefs have won several Best Brief Awards from the National Association of Attorneys General. He has argued some of the state's biggest cases in the last 20 years on topics such as the constitutionality of charter schools, partial birth abortion, nude dancing, concealed carry of handguns, free speech, wrongful imprisonment, and an advocacy group standing to challenge JobsOhio. He joined the Attorney General's office in 1997 after spending 3 years in general litigation at Jones Day here in Columbus. Mr. Carney is a graduate of Xavier University and the University of Cincinnati College of Law. Stephen, thank you very much for being with us. I will turn it over to you.
Well, thanks so much for having me. I will watch the clock since we're getting a start now and try to balance this. I want to say a few introductory things about myself and what I hope to do for the rest of the hour, and why I think this is kind of always a challenge to me, because 2 things make these year in review kind of cases or kind of speeches different. I've been doing year in review things at different groups, the Bar Association. And so for a long time, and sometimes it's all about the US Supreme Court or the Ohio Supreme Court. I've been doing one for the State Bar Association for years that's just about the Ohio Supreme Court. And we cover everything, and this one is employment. And the reason I found these were getting harder, even 10, 15 years ago, is that there's so many blogs, the SCOTUS blog and these things where instead of getting a newsletter in the mail, you could just catch up with everything. So you guys already know a lot of these big cases. Some of the things I want to tell you, you've already heard. So if it's just about rattling off 50 cases and saying, this happened, and just giving a minute each, that's stuff you already know. So what I'd like to do is talk about employment. I'm not going to talk about non-employment cases, but for at least the first few, do a really deep dive into what the court argued back and forth, and not only what the arguments were, but how that reasoning goes beyond just core employment law, because some of the biggest cases in employment law have been things with free speech or free exercise, religious cases, some hot topics there. The Bostock case last year said Title VII covers sexual orientation and gender identity. And they have this whole debate over how to do statutory interpretation. And those, I think, are more generalist things that are partly maybe more interesting than you see every day in just, these bulletins and bullet points about the latest case from a district court in Montana finding arbitrability under the particular CBA of a particular employer. So I'm going to try to be a bit more big picture. And that's also, I admit, totally cheating, because those are things I know about more as an appellate generalist, is how this all works. But I do want to also say, standard disclaimer when I speak, one, I'm loud and I talk too fast, so send me a slow down high sign. And also, I'm planning to leave some time at the back end for questions, but feel free to jump in. We're not a huge group. Throw out a question at any time in the middle if something doesn't make any sense or is curious. And the other thing is that everything I say is me as a person in my attic. Welcome to, it's got the slanted walls and everything, or ceiling. And it's not on behalf of the Attorney General's office, the Attorney General personally, or any sane person on the planet who would say what I will say. And that's especially true because some of these are some hot buttons, and also some of the ones are cases we've personally been involved in, making predictions about a pending case when the state is the litigant. I don't want to say, yeah, we got this in the bag or something. You should be aware of where I'm coming from is not speaking for the office. So if all that makes sense, I'm going to jump in and talk about a handful of core cases, maybe rattle off a few bonus if I have time. But I'll tell you, I'm going to focus on some U.S. Supreme Court because they're big and fun. And also because, as you know, the sheer quantity of employment law, of just applying law to facts, of every summary judgment decision, of every Title VII claim, that's just not that interesting, unless you're on the hot seat for one. So I'm going to talk about the U.S. Supreme Court with a handful of cases they've decided this past end of year, in May and June, which I hope was later than last time you did an annual update or so. And then I'm going to mention a bit about some they have on the calendar right now that are coming up that have an employment core, or at least a significant employment overlap. So the first one I'm going to talk about, because it was a blockbuster, is Bostock versus Clayton County. A lot of you may have heard about it. It was a big deal. Came out at the end of the year, or I mean the end of the Supreme Court's term, which is June. And we all know for Title VII that you cannot discriminate by race, sex, and that includes discriminating in everything: hiring, firing, pay, whatever. And what the court said was that that bar on sex discrimination also covers sexual orientation and also covers gender identity as transgender. And that case was an earthquake and will still have lots of ripples for a lot of reasons. One of the biggest things about it is, as some of you may know, that particular argument had been covered in literally every circuit in the country in the federal courts back in as early as the 80s and into the 90s, and everybody rejected it and said, we all know, whatever your policy views, and if you think strongly this ought to be extended to orientation, that sex, whether you're male or female, or whether you're gay or straight, that's just a different thing. It's for Congress to change it. And of course, there have been bills introduced in Congress since, before I was in law school, saying, let's do that expansion. And the court said that law, it's been there since 1964, has had it in there all along. Now, there were a couple of circuit courts who started to disagree and question their 90s decisions before it got here, before it got to the Supreme Court. And so what the court said of why we have overlooked this in the past is this, and here's where this is really fun in statutory analysis. The phrase in the statute in Title VII is about discrimination because of sex. Discrimination because of sex and race and those other things, but those don't matter here. And just those 4 words, discrimination because of sex, are the whole battle, because the court, and in particular Justice Gorsuch, who wrote the 5-4 majority opinion with several judges that are usually considered liberal or left justices, and I always dislike those terms because I think the law and politics are different, but I know the world speaks that way, so I use that shorthand. But the conservative justices all dissented here. But Gorsuch is a very conservative guy, and he joined this decision. He wrote this decision. And so what's going on with the text? Well, he said, if you just start with the word sex and say, does the word sex include sexual orientation in the dictionary? No. If you say, put all the men on this side of the room and all the women on that side of the room, that means one thing. And if you come back 5 minutes later and say, put all the straight people here and put all the gay people here, that means something different, because there will be men and women over here. So sex doesn't mean the same thing. But he said, that's too narrow to pick on just one word. The phrase here is because of sex. And he said, because of sex means anytime you have but for causation where this would not come out the way it did but for your sex, then that means that the treatment at issue, hiring, firing, whatever, was because of sex. And so therefore, if you say this employee is a male who brought another male to the Christmas party and the next day I fired him, you say, well, if he were a female employee and he brought a male to the party or had a picture up of I'm married to a male, this wouldn't have happened. And so it's because this person is a male or female. And so it does meet the standard because of. Very literal, very textual. He acknowledges, look, yes, that's not what anybody in 1964 had in mind, really, the Congress in 1964, but that's where we are. It is because of. And it goes through all these examples of where it's because of. But the dissent comes back and says, if you're going to go beyond the word sex to because of sex, you need to go one more word and say discrimination because of sex, because that's what this law is all about, is discrimination. And there they say discrimination is, treating one group different from another. So to use the example of how you treat people differently, but there are several different dissents, but Justice Kavanaugh, I think, does the most with this, says if somebody were a discriminator and said, I want to fire all the women, they'd ask the HR, give me a list. But if someone said, I want to fire gay employees, I object to all gay employees for some reason, well, that list would be both gay men and lesbian women, and they would all be fired. So you're not discriminating. The boxes don't line up because both men and women are being fired, even though they're all gay. Both men and women over here are being retained, even though, they're all straight. So there's no discrimination. You're not treating them different because of their sex. You are treating them different, but you're treating them different because of another factor. So they have this grand battle over this. And of course, there are other things that happen in every case also going on. Like did the Congress really intend this? And I don't think anybody really argues about that, about 1964, but also sort of your view of courts of, look, this is a big change and people have very strong views about it. And shouldn't we just wait? You know, the House passed this change once. The Senate did in a different year. They just never did in the same year. And if you look at the current House and Senate and president, probably would have happened this year if it didn't happen, you know, in this court case last year. So there's a lot going on there about how statutes work, a lot about how to interpret. But ultimately, this expansion is, it's both big or small, depending on how you look at it. I know some people who say, even though this was a blockbuster, that it's actually kind of a small effect because, you know, yes, there were these particular cases of people who brought this up, but for the most part, some people believe this is happening at smaller employers. Most of the Fortune 500 is very friendly, very different today than 1964. And also a lot of states already have this, a lot of cities have ordinances. So how much is that actually going to change? You know, we shall see. But where I think it is going to change a lot is in a couple of ways. First, Justice Gorsuch's opinion goes out of its way to say, we are only deciding today this Title VII case and only about hiring and firing. We are not dealing with bathroom issues that make all the papers, and we are not dealing with dress codes and different things. And there's some people who say, well, wait a minute, that's not fully true, because when it comes to your logic of because of means you're treating the man different from the woman because of, if you have an employee who just, you know, a man who bursts into the ladies' room and doesn't have an identity difference or anything that would bring that up, if he just goes in there, you would say you're breaking the rules, you're invading someone's privacy, you know, or dress codes. There are a lot of dress code cases in the circuit before this one that say, you know, the famous casino case of women were expected to wear makeup and, you know, wear skirts while the men had to wear pants. That those things are because if I show up in a dress, that means one thing. If a woman shows up in a dress, that means another thing. So some people think those cases, and I think realistically for most employers in America, the part of the case about gender identity will actually have a bigger impact than the part of the case about being straight or gay. Because I think there are a lot of employers who don't really care about who you're married to and don't really care about that, but do care in ways they consider legitimate about dress codes and treatment and some of those things. But the other reason I think that is going to have a big impact, again, probably more on the transgender side than on the gay or straight side, is that the same language of because of sex is in our Title IX law in education. And I know this is an employment discussion, but that's where there are all these hot button issues about kids in sports and playing on the boys or girls track team or whatever. And so all of those things are going to be coming up the pike. And so if you are an employer, I think the thing you've got to watch for is, you know, where do you have anything gendered in your treatment, in your employee, anything. But the other thing that I think is important is to keep in mind, because a lot of you, if you litigate or your clients and you're having people litigate, is that the biggest difference, I think, in a lot of these cases, and this is true of the next case I'm going to talk about too, is it's not so much that the discrimination happened or not, but that when the law doesn't even cover it, you get a shortcut. You file your 12B6 and you're out. So maybe in these particular cases, no discrimination occurred, and you would have your garden variety case like you do in an existing Title VII race or sex case of, I fired him because they were late 3 times for work. No, that's a pretext because this other guy was fired or was late 3 times and didn't get fired. Well, you know, here's the, and you're the employee, and it goes all that stuff that costs a lot of money and discovery and going to a jury trial. Whereas if you just happen to have the convenience of this employee that you think you fired for all sorts of meritorious reasons just happened to be claiming orientation, you could just say, well, he's fired, 12b6 and be done. So I think it matters procedurally for that. But when it comes to how many cases are going to actually win awards or not, I think that remains to be seen, and goes along with all the cultural changes in America of what's really happening on the ground at different sizes and different types of employers. So that's very fascinating. Happy to throw in questions on that one now, or throw in everything at the end. Just let me know. But one of the biggest areas, and this is where this other case I'm getting to is the other side of the coin, is while for a lot of corporate employers or government employees that already have policies against orientation discrimination, the main effect of Bostock is going to be the one shortcut I said, that basically you just get out on a 12b6 and you don't have to litigate the case on the facts or anything. Well, one area where there actually are substantive, yes, that's why we fired you, cases are the religious ones, with religious employers, particularly schools, of we disagree with that, so you can't teach English here anymore. And that's where, this big clash and cultural clash, and, I hope I just describe everything fairly of just what the courts are saying and what both sides are arguing, and, not actually debate that. But the religious exemption that the court discussed in employment, in particular, the ministerial exemption in a case just last spring, Our Lady of Guadalupe schools, is to me not only huge on its own, but there was a case a couple years ago called Hosanna Tabor, where it was an age discrimination claim. These cases here are also age discrimination and disability discrimination. And they have nothing to do with Bostock and orientation. But as soon as those come together and you have orientation, firing teachers at a Catholic school, that's going to be the big explosion. So let's talk about what Guadalupe said and how we got here. What was interesting about Guadalupe, it said in its bottom line that these couple of Catholic schools in California were not at all answerable to ADA or ADEA charges, because these teachers who taught all day a variety of subjects, but that included religion in there, were ministers for the purpose of this ministerial exception. And so they had an exemption, and the church could hire or fire who they want, and so could a school affiliate it with, and so they had no claim. Now, what's fascinating about this to me is a lot of people don't fully appreciate the difference between the constitutional basis of the ministerial exception and how broad its scope can be when it is kicked in, and the statutory Title VII religious exemption. A lot of you may recall in Title VII, where we say don't discriminate by religion as well as race and sex. So, don't fire the person at McDonald's for being whatever denomination or non-religious or whatever. There's been an exception since, I think it was 67, a few years after the 64 Act was passed, that says, well, you do have this exemption when you are a religious employer and you're discriminating by religion. So, yes, you can say we run a Muslim school, we want all the teachers to be Muslim. You can do that. That's right there in the statute. But what the ministerial exception does when it's triggered is it goes broader. It says, because you're a Muslim school, that for certain teachers, you don't have to follow Title VII, the age discrimination law, the state laws too, because it's a constitutional right under the federal constitution we all have to follow. So you get a free pass on everything. And I run into a lot of people who say, wait a minute, well, why do you need to racially discriminate because you are a Catholic school or a Lutheran school or whatever? And the answer to that is that when you go deeper, both into the Constitution and into how you litigate a Title VII case or any discrimination case, ADA, is all of a sudden it becomes clear. And that it goes back to these contract cases where there was a property dispute when one Orthodox church broke off from another and the Serbians were fighting with the Russians. And there's similar cases like that going on today where these Episcopal parishes break up and they argue about who owns the land and who does this, or even if you fire your local minister at a particular congregation, is that the view of the courts is we can't decide who is a valid minister or not. You hire your minister, we just don't touch it. But where that also comes up is, in a standard litigation case, it's all about causation. And you say, I was fired for this discriminatory reason. No, it was for this reason. That's legitimate business purpose. No, that's just a pretext. And so where you can imagine is in registering a pretext defense, or saying it's a pretext so there is no legitimacy defense, is a jury ultimately has to decide, do we believe you? And we have to say, for example, let's say some teacher gets fired and says, you're firing me because of my race. And so that's a hot button. Everyone knows that's illegal. That's the worst. Yeah. And you didn't hire me because of my religion or fire me because of my religion. You fired me because of my race. Well, if the school comes back and says, we fired you because you ate a ham sandwich in the cafeteria on Friday in Lent, you could see how, well, wait a minute, was that your real reason or was that a pretext? A lot of juries might think that's got to be made up because nobody really fires anyone over what they have for lunch. But to someone who takes that very, very seriously, or it could be a Jewish school or a Muslim school where they don't think you should be, if they're keeping kosher or halal, they might not think you should be eating pork at all in their cafeteria. And so, yes, that is why we fired you, not because of, the forbidden reason. And so the whole idea of the courts of this exception is back off, you decide who your ministers are. But it started with actual, preaching from the pulpit ministers, where all of a sudden it started migrating was throughout the decades, there were cases in the appeals courts, but the Supreme Court had never touched, extending that to a lot of teachers, also various other jobs too, but especially teachers. And the Hosanna Tabor case, which was a couple of years ago, dived into this and did a really thorough explanation of why. And in that case, it was here from the Sixth Circuit. It was in our home circuit. A teacher taught at a Lutheran school, and she taught all the different subjects all day, but she did have a slot where it was religion for 45 minutes. But she also had gone through some religious training to get a certificate and was a called minister, they called her. And the Sixth Circuit had said, oh, you're not really a minister. You're mostly a teacher. You teach math, you teach art, you teach, because it was a grade school where the same teacher teaches everything all day or so. And they said, you don't count as a minister for this exception. So we know what the exception does once it kicks in, but it doesn't kick in for you. And the U.S. Supreme Court in Hosanna Tabor reversed that 9-0, which is amazing when you think of these other religious cases that are 5-4 and controversial. This was 9-0. And they all agreed this teacher is exempt. So they threw out, again, a disability claim, not even a claim based on religious discrimination, but a claim based on disability. And so what happened is all these courts around the country go, okay, teachers, we got you. Teachers who teach one class a day. Well, the Ninth Circuit in a couple of cases, or two paired cases, said, oh no, these teachers, and this time it was a Catholic school instead of a Lutheran school, and again, it was grade school teachers who taught a variety of things, but they said, that teacher in Hosanna Tabor, she had an actual special training in this. These teachers, they just get their curriculum book and go. And their religious teaching isn't that much of it. And one of the two plaintiffs at issue didn't even teach a religious class. But what the Supreme Court said, so they distinguished those from the Hosanna Tabor case and said, you're not ministers. These teachers are still under the law's coverage. Well, the Supreme Court reversed, and fascinatingly, they did it 7-2, which I'll come back to. They said, when we said the teacher thing back in Hosanna, yes, we gave general guidelines, and we said this won't count everyone. It might not mean the janitor in the hospital that's a Catholic hospital or Jewish hospital or whatever faith tradition runs hospitals or schools or any institution. It doesn't mean everyone, but we look at the sort of what your job is, what you do. And they said, but we don't want to be too mechanical about that. we wanted, if it's important, like they highlighted one of the two teachers, everybody on the faculty was expected to come to liturgical services together once a week and things like that. And they said, as long as the church thinks it's important, or the church affiliated institution thinks it's important, well, then we're going to defer to that. And two of the justices, Ginsburg and Sotomayor, dissented and said all the reasons this is different. And what that tells me is I think we're going to get a flood of litigation, even though Hosanna Tabor was 9-0, on the where you draw the line. Is a school going to say we are exempt for everything because we have the name Lutheran Services in our job title, and we run this hospital with all these employees who all day are taking blood and nursing and doing things not remotely related? The court is not going to go that far, I'll predict that. But some of these other jobs that are like a doctor in a hospital, well, some doctors are supposed to follow, Catholic Church teaching. And I'll, in interest of full disclosure, I'm Catholic, so I know the rules and regulations better. I'm not trying to pick on them, nor am I trying to hold them up as an exemplar. I'm just saying I know the examples. So there are a lot of surgical things that doctors are not supposed to do at a Catholic hospital. So it does intertwine there a lot. And so teachers will be number one, but I think hospitals will be number two on just calling balls and strikes of which people are covered and which people are not covered by this ministerial exception. I think that's going to be a hot topic. It's also, unlike this very narrow statutory approach in Bostock, it's the Constitution. So, courts do all sorts of things. So if you are either plaintiff side and your employee client works at any place with even an affiliation, which does include, all these colleges that have very loose affiliations. Some of them are even stepping away from lately over some controversial issues. That's going to be an issue of, hey, can we just get an out based on our exception? And what you're also going to see as a counseling matter in terms of if you counsel institutions is more and more places are going to put in their handbooks, we think everybody needs to be on the same page about this so they can establish that factual track record of we want our janitors to say prayers in the morning with all the students at the assembly. We want to do things to firm that up. And again, that's not necessarily because they want to discriminate, but it's because it gives you a free pass. It doesn't matter if it's race, if it's disability, if it's age. If you can say all my employees are ministers, I could get the heck out of this. And that's obviously very attractive, even to an employer who in good faith doesn't ever want to discriminate because it's such a strong wall once it kicks in. So how broad that expands or not is going to be really interesting. I think the next couple of cases are, I'm going to hit some smaller ones since I talked so long about those two, and then get back to some bigger ones again to sort of mix up how many minutes per case. These next couple of cases are statutory and kind of narrow, but kind of fun. Comcast and BAB, and they're sort of two sides of the same coin in different ways. Comcast is actually not an employment case. It's a contract case, but it's a contract case under Section 1981. Some of you may know 42 USC 1981, part of the original Civil Rights Act right after the Civil War, says you cannot discriminate by race in contracts. And that law is simultaneously much narrower than Title VII, but it's also much broader than Title VII. For starters, it does cover employment because it's a contract. Even if you don't sign a piece of paper, hiring and firing is always a contract. And so you are covered by this if you racially discriminate, and people can use 1981 either instead of or in addition to Title VII when they have a race discrimination claim. It's narrower because it's only race and national origin. It doesn't cover sex, so therefore it doesn't cover orientation and expansion from Bostock, but also doesn't cover disability or age or any of the things in other statutes. It's just race, so that makes it much narrower. It's also narrower because it only covers intentional discrimination. It doesn't cover any disparate impact theory. And if you know the ratio of disparate impact versus intentional, particularly when you have class action things, That's a pretty big narrowing. But it is broader in a couple of ways. You don't have to file an EEOC charge. And as a corollary to that, you don't have to meet the 300 days to file the EEOC charge, the 90 days after you're getting your right to sue letter. You have a statute of limitations of 4 years. So if you're out of time, if you've got a race discrimination and you don't have a way around the EEOC on one of the various doctrines that get you around that, you also have no cap on damages. So that's attractive to people, unlike Title VII. Well, what the court held in this 1981 case happened to be a contract. It was a black themed cable channel that couldn't get Comcast to carry them. That's what they're like, nope, your channel doesn't have enough viewers. And like, no, you're discriminating because of our race. But this will apply in employment cases too. What the court said was that the causation element of don't do this because of, you have to show that it's a but-for cause. So echoing, the but-for cause in what we were talking about of but-for in gender in Title VII. But they said it can't be a mere motivating factor. So if you have mixed motives, but I would have done the same thing anyway, well, it kind of give me an extra oomph. It's a motivating factor. Motivating factor is acknowledged in other employment statutes as enough to get you in trouble. But for 1981, the court said you have to show but for race, this action would not have happened, whatever the action is, firing or whatnot. What's interesting about this is Babb versus Wilkie, which came out also around the same time, is the flip side of the coin. In the age discrimination law, federal ADEA, the court said all you have to show is that age is a motivating factor. You don't have to go all the way up to but for. So that greatly expands, how many cases are caused by it's a motivating factor. But then to make things even more complicated, because it's the Supreme Court, we got to be complicated, is the court said the difference between motivating factor and but for, which you don't have to overcome at the higher standard to win a basic violation, does matter for the remedy. So what happens is, if you show just the motivating factor, you can get an injunction or you could get forward-looking relief. So if you say your system of doing employee reviews or so lets age sneak in as a motivating factor, you can go to court and enjoin that. However, if you want any of the hiring reinstatement, if you want back pay, if you want compensatories, then you still have to show the full-on but-for causation. Excuse me. So arguably this won't make that much of a difference, because even though that seems philosophically a big deal to say you can meet this lower standard, the question is, as a practical economic question, and you guys know better than me, how many people bring a case or get a lawyer to bring a case if there's no damages, no back pay, if all I can get is an injunction? If it really is an important structural practice and you really do have like a class together or something, then sure, you can get that violation and get that relief. But in the run-of-the-mill single plaintiff case where there's no money at issue and you can't get reinstated, I don't think we'll see a lot from that one. But it's interesting, and it also shows how much, if you contrast that to the same question of but-for versus motivating in 1981, is sometimes these statutes, and we see this all the time in all sorts of areas, sometimes these statutes seem very similar. The age one, the ADEA, or the disability one, the ADA, or Title VII. Sometimes all of those are in lockstep on certain issues. Other times there's a subtle difference in the wording from what they adopted in the ADA in 1990 to what they had said in Title VII, where they go a totally different direction. And this was one of those, that 1981 goes a different way from the age law on the kind of causation you have to show. That pretty much covers my employment, backward-looking section about what the Supreme Court has done. And I just want to pause for a second and see if my Zoom is just limited. My view has just like 3 of you, or did we Or do I just not get to see everyone, like if they raise a hand or something? Maybe I'll switch to gallery view. Okay, hi everybody. I don't know, is the Zoom kicking people out? A lot of the people who were here earlier?
No, it shouldn't be. We have 22 people in attendance.
Okay, for some reason it's showing me 3, and I'm happy to talk to 3 people. I love all 3 of you. I just wanted to make sure I didn't do something wrong on my end on the tech. So I want to give a little bit of preview, again, continuing to focus on the U.S. Supreme Court, but I do have at least one hot Ohio Supreme Court case to get to, and maybe a few nuggets if I talk fast enough elsewhere. On the agenda for this year in the Supreme Court, its term runs from fall 2020 through June 2021, are a couple of cases. Frankly, it's a really low year for employment. There are no big cases about the scope of Title VII, no big case about the ministerial exemption. And the cases that are there are only tangentially related to employment. They might seem, but at least a couple of them have an employment effect. So one I'm going to say a little bit more about. The other ones I'm going to barely mention because they don't do that much. Anyway, thank you, Bernadette, for clarifying. It's that people don't have cameras on. So I'm seeing people who are camera. So everyone else can be eating their dessert at home and not showing me that they have key lime pie and I don't. And I know Don's one of them. Don and I worked together for many, many years. He's been my client as well as my colleague. So I'm only going to pick on him as a name to say. So one of the, I think, fascinating cases that is, it's a criminal case. What the heck does it have to do with employment? Is called Van Buren versus United States. And this one is worth a couple of minutes because it doesn't involve employment litigation or hiring and firing, but it involves policies and some things that a lot of employers do. And because the facts are just fascinating. So I can't resist. If you're going to have a, lunch Zoom, you got to hear at least one fascinating story. So Van Buren versus United States is a case that's pending. They already heard the argument. Decision will come out at any time before June. And it is a criminal case, a prosecution under the Computer Fraud and Abuse Act, which goes back to 1986. It's been tweaked since the 90s. And it's about unauthorized access into a computer. So it starts where it's about hacking. If you don't have access to a computer, you break into, the bank computer, and that's a crime. You can go to prison for that. Okay. How does that come up with employees? All the time. Because employees have access to all this information, some of which is authorized and some of which isn't. And if you use your work computer and you find a way that they didn't put up a good enough firewall or password, and you're supposed to just be part of the general employment part, and you break into the HR files and start reading other people's personal information, you can be in trouble for that. And so employers in management have to always monitor, like, are my employees using my system and getting into it wrong? Well, this case was a doozy. Mr. Van Buren was a police officer in Georgia. And so one of the things he had access to was a database of license plate information and driving records. And we have this at my office, the Attorney General's office, where we run these law enforcement databases, and they're very strict in telling us not just some people get to see those and others don't. I'm just a stupid lawyer. I don't get to see them, but our people in our BCI, Bureau of Criminal Identification and Investigation, the state version of the FBI, they get to see all that stuff. They get to look up stuff on every citizen in Ohio and even people around the world because it's shared with these national databases, international databases with Interpol and everything. So they're very strict about you only use this for an assignment you have, because I'm sure you've seen in pop culture, there are people, if they've got a job as a deputy sheriff or they're, working in the IRS, as soon as my sister calls and she's dating a new guy, I'm going to look him up and see if he's rich or poor based on his tax return, or I'm going to check on, my neighbors and if they've got DUIs or all sorts of things and records that the government keeps on all of us and things that these employees are only supposed to use for certain purposes. Well, this cop, he looked at stuff he wasn't supposed, or stuff he would normally be allowed to see, but for the wrong reason. And what happened was, this has got all sorts of scandal about it. This cop had this friend who wanted to check on this stripper, and there's maybe this prostitution ring, and he wanted to look up. This cop asked him, I'm sorry, not the cop, the bad guy, this underworld sort of shadowy figure said, I'll give you $15,000 if you find out whether this person is a police officer or not, because I think she might be an undercover agent. And so as part of his interesting storyline, he paid outright cash. So this guy was bribed, okay? And that's pretty bad. And he used a police database that he had access to. And once someone suspected this, they ran a sting and had a new person, this FBI informant, ask, hey, will you get into this database for money? And all sorts of things happen. And what the issue comes down to is, does this law that says authorize access in order to, and this particular part about obtaining information is, does it cover when you have authority, but you don't have authority for that purpose? And that covers a wide swath of people who abuse these databases. And the court at argument seemed kind of skeptical about that. And one reason it might not have that big a deal is a lot of states have policies, or the employers have policies, where wrong purpose can at least fire you and stuff. But the prosecution of seeing prison time ahead of you, that's much more serious. It's one thing to fire someone for you looked in the wrong database, or you looked in the right database for the wrong reason. But it's another thing to say you're going to go do 10 years in the federal pen. So Van Buren is pending. We'll see what happens. The fact pattern was just crazy and interesting, so it's part of the reason I indulged in it. But also because it is a pretty big issue in employment about employee access to things. There are a couple of other cases that some people list as employment related that I don't think really are. For example, just give a quick hit on the ACA, the Obamacare Affordable Care Act. They heard an argument in November. It was huge, made all the papers for other reasons. It's a challenge to the individual mandate and whether each individual has to buy health insurance or it's enforceable by federal law. That got upheld a couple of years ago as a legitimate exercise of the taxing power, 5-4, very hot button thing back in 2012. And ever since Congress repealed the actual penalty, so you don't have to pay a penalty. It's on the books as you have to do it, but if you don't, nothing happens. Whether they strike it down or not kind of doesn't matter in one sense, because you don't have to get enforcement. Why this case matters, though, and why it made a big deal, is that the one side is arguing because there's an unconstitutional piece of the puzzle, the whole law, everything has to get thrown out. And that would include the employer mandate, and every employer mandate coverage to provide insurance with so many employees and have this kind of degree of coverage. All that would get thrown out. The reason I think that's ultimately not a big deal is, and here, bias alert, my office wrote an amicus in this that got some attention. I don't think there's any chance that they're going to strike the whole thing. I think they're going to say, sure, that piece is gone, but the rest still stands. So the employer mandate and all the employment benefits that have grown around it for a decade now are not going to change. But it was listed on a lot of cases to watch because of the employment aspect. Another one that was listed on the employment stuff for this year that unfortunately went away because it's a fun little case was about threshold issues of arbitrability and arbitration agreements. And I know a lot of you deal a lot with arbitration agreements. And one of the things they'd said a few years ago was that if you have a claim that might fall outside of arbitration, that goes straight to court, but the arbitrator still gets to take a whack at deciding if it's arbitrable. Like, I'm going to decide, and that matters because if the arbitrator takes a whack at it, then her decision will be then given that standard of review when later you challenge it, versus just filing a fresh case where you're outside of it. This was a subpart of that comes up more than some people might think, where if there's a category breakdown of certain, not just arbitrability, but we carve out certain areas are or aren't and clearly put some out, does the arbitrator still get to make that threshold finding? But the court heard this whole argument, had all these briefs, and then in January, in one sentence, without explaining why, they threw it out. They call it dismissed as improvidently granted. And so that's still a hot issue for some people in that field, and it'll come back someday, but who knows when. But that one didn't come out. So that covers my U.S. Supreme Court things. There are a couple of Sixth Circuit cases that have come out recently, but they're very narrow, very fact-bound. But if this is your field, I'll mention them, but not go back and forth into the reasoning or dissents or fact pattern. There's a case called United Steel Paper and Rubber Manufacturing, AFL-CIO case, that did talk about whether a employer who refused to arbitrate a dispute had breached, and the court found that there was standing for them to complain about that, but it still got thrown out on a 12b6. So the details of thresholds, and it was on the language of this particular CBA, but that's fairly new. It's just a few weeks old, so if that's your field, you can look that up, but it's not huge. And then there was another case, United Auto, Aero, and Agricultural Implement Workers, where the court said the NLRB went too far, violated the reach of the NLRA in a particular finding about inadvertent error by a union constituting a ULP, an unfair labor practice. Like, we didn't mean to do it, and NLRB had said that's still an unfair labor practice just because you didn't mean to, and the court says no, NLRB, you went too far on that, and tosses it. Other things that I've just seen just starting to bubble up are there's a case just recently in the Western District of Kentucky in our neighbor state, and so it'll be going to the Sixth Circuit, are cases about the Families First Coronavirus Response Act. There are all these new provisions, and they're too detailed to go into, but all of these things that are coronavirus COVID specific about taking sick leave that's mandatory now that an employer has to have if you're ordered to quarantine. So if I'm told County Board of Health says stay home, well, then I can't come to work, but they have to give me leave over that. And this was a classic case. This was a McDonald's worker whose husband tested positive, and so she had to stay home, and there's a fight over that. So it's very novel, obviously not a lot of case law because it's all brand new, but more of those are coming down the pike. They just take a while to mature into litigation of people who are being let go or not when someone says, oh, I fired you for this reason, not, or didn't get paid, didn't get their money for the weeks they missed. One other federal one I want to mention because it's pending in the Second Circuit, but it also segues to sort of a broader topic as a whole because it's a hot legal area to watch. Is there is a lot of case law going on right now in employment and in half a dozen other hot button areas on everything from environmental law to abortion law about administrative rules from the presidential administration. And what keeps happening, of course, is there were some rules that the Obama administration put down one way and the Trump people came in and put another way, and now the Biden people are doing another way. And as we zigzag, people run to court right away, of course, and say, your rule is illegal, either the substance of it, because it's not consistent with the statute, or the process. You didn't go through the APA to do these rules right. And because of that, we have a case going in an environmental area where if they strike down this Trump repeal effort, that would actually revive an Obama era rule. And so other cases keep going back and forth like that. Particularly, you may have seen there's an immigration case where they said, you might have had the right to do that, but you didn't go through the right reasoned decision-making process. These are big because some of these are happening in really big impact areas in employment. This one case, New York versus Scalia, came out just a couple of months ago at the end of 2020, so it's pending in the Second Circuit. As what happened was the administration, the then Trump administration, did a rule that would change the rule for joint employers. And if you do, especially traditional labor, where it counts that you work at McDonald's, and so you're an employer somehow of McDonald's as well as an employer of the local franchisee, that puts a lot more employers on the hook if they're considered joint with the other employer. And the test for primary and joint employer, the test of what includes, there's just a lot of detail to it that I don't have time to go into, but this rule narrowed things. The district court in New York said, that rule is invalid because it's not true to what the FLSA, the actual Fair Labor Standards Act, says statutorily. So we're going to strike down that rule. Meanwhile, while that's pending, the Biden administration has announced they want to get rid of this rule anyway. And so my guess is people on the other side of it will sue them saying you didn't get rid of the rule properly. So joint employer, it's up in the air. They're competing rules regimes. It's going to continue to be litigated. And the reason I mention that is that there have been several employment changes, some of which are, in the actual Congress to pass by statute, but there are several things going about, for example, new DLO, Department of Labor order on who's an independent contractor versus an employee. And there's various NLRB things where the administration will change it. So the court second guessing the administrative changes as measured against the statute is going to continue to be a hot area because the extremity of the depth of how quickly the executive actions swing versus, honestly, some of the big changes that happened from Bush to Clinton or Clinton back to the other Bush were pretty big, but some were within a smaller range than some of the really strong differences from the Obama to Trump. The executive differences in regulatory field are really different. And so many of those are employment related. FLSA, definitions of employer, definitions of, who's overtime exempt, all sorts of things over the years in the admin area. And of course, lots of statutory things are pending in employment, from raising the minimum wage to enabling organizing more easily. A lot of these things have passed the House and are all in the control of Joe Manchin, the swing senator from West Virginia, who's apparently replaced Anthony Kennedy as the most powerful man in America. Bit of an editorial comment, but it's a good or bad thing. It's a real thing. So I want to talk a little bit about, in Ohio law, a case that is both really fascinating, but we don't know whether they'll hear it yet, but that's what makes it fun. And other Ohio cases, there's not a lot that was really hot this year in the Ohio Supreme Court. But the Portage County Educators Association versus SERB, the State Employment Relations Board, is about picketing and the First Amendment. So that's going to be hot. I'll tell you a little bit about the law and what it does and the procedure. The basic thing is that the court has not granted review. They haven't agreed to hear it, but they're likely to. Again, bias warning. We actually have hired special counsel for the specialty on it, but the Ohio Supreme Court's decision is, my client, SERB, Don's home. We have, so when I say I think we're going to win this, I'm not speaking for the office of I think we're going to win getting it in. But the court's got to decide first whether to take it and then get to the merits. So what it's about is, going back to the mid-'80s, the law in Ohio says that it is an unfair labor practice for a union, an employee organization, or its agents or representatives to induce or encourage, in connection with the labor dispute, to picket someone at their residence or at their place of private employment. What that means is the teachers union can, of course, picket all they want in front of the school building. They can even go picket in the village square that has nothing to do with the particular school, or picket along the street and have a march up and down High Street. But if they go organize an effort to go to a school board member's home, which is sort of amped up in certain years as a pressure point of, we're going to go march around your house. Or if we go to your private employment, which puts pressure on the employer of, oh my gosh, our person who works here as a manager in this area also sits on the school board on the side. And now we have all these people marching around. We want our attention drawn to us. And so the law prohibits that. Well, there have been several decisions over the years, both upholding and striking that down, either as to residence or as to place of other employment that's not the school board or whatever public employer you work for. And one way back in the late 90s, the 8th District up in Cuyahoga County in Cleveland had said this was unconstitutional as to extending to residences because people have a First Amendment right to march in the streets, and even though it's in front of your house, as long as they don't trespass on your property, they can march up and down the sidewalk and picket your house. But then this Harrison Hills case about 3 years ago, I think it was, the 7th District Court of Appeals said no, as to the place of employment part, this law is perfectly constitutional. I'll get to the merits of why in a second. And in this case, it involves both. This union picketed both someone's house, several people's houses actually, but they picketed one of the board members' place of private employment. And what the argument is of why we can or cannot have this state law is, you may remember from free speech law, there's this idea that you cannot regulate content. And that's unless you have the most strict scrutiny satisfied, a compelling interest, and it's narrowly tailored. When you tell someone you can talk about topic X, but don't you dare whisper a word about topic Y, you're probably going to lose as the government. But we can do time, place, and manner restrictions. We can say nobody marches in the park past 10 p.m. I don't care what your cause is. 10 p.m., the park closes, no more marching around. Time, place, manner, very common. And those do get some scrutiny, but they generally pass. And so to the state, this is as classic a time, place, manner as you can get. Why? Because you can have your picket line about this labor dispute anywhere you want, except at that woman's house or at that guy's place of private employment. So that's a place restriction. Isn't that pretty straightforward? No, says the other side, and the court agreed with them here, because they said, you know, this time that the U.S. Supreme Court upheld in this famous case called Frisbee versus Schultz that said, don't go marching in somebody's neighborhood, and you can do a city ordinance or a state law that says no picketing at residences. What they said is this law is content-based. And from SERB's perspective, well, it's not content-based, it's about place. But someone says, well, the problem is SERB only has jurisdiction under this statute to do this for labor disputes, which means if for some reason we wanted to go to the same locations of this school board member just to encourage them to oppose a war, you know, I'm opposed to the Afghanistan war still going on, you can march up and down their street in front of their house. But if it's a labor dispute, you can't. So to the court below, as long as this labor trigger is there, that means you can speak about the war, you can speak about, you know, COVID, you know, I don't want to have a mask rule. You can speak about anything you want in front of Jane Doe's house, but you can't talk about labor and hold up a sign that, you know, they're not paying us enough at this particular place. And so to them, it's obviously content. But if you look at it from the other side, it's obviously place, because you can share that content anywhere you want. That has been a confusing area in federal law for decades now. The U.S. Supreme Court cases in the area, frankly, are a mess of how they deal with. And I think the proper term is that it's not purely content and not purely time, place, manner, but that it's a hybrid. Because we say, if you're talking about this topic, then doing it only in this place. And so the question is, well, do you approach that more as a time, place, manner? Because after all, you can still do your thing any other time. And then the backup arguments here, if you get past that core issue, are about the idea of, do we have a compelling interest here in labor peace generally? And do we have a compelling interest in wanting people to serve on school boards? You know, these are part-time positions. And if people think you're going to be in my front yard every third year, when there's a bargaining going on, or you're going to show up at my employer, I'm not going to want to serve on the board. And that's true. A lot of people do not want to get involved in public service because of the backlash. And in the area of Twitter and everyone, flash mob to show up all at once, that's increasing. So it's a fascinating case. The court has not yet decided whether to take it, but the court below certified a conflict, and a conflict certification gets in the court like 99% of the time. The court said, we're going to rule against the state, but we acknowledge we have a conflict with the Harrison Hills case from a couple of years ago. So court, you ought to take it. So it's not just the party saying, please review that I lost. It's the court below saying, take this case. Now, the union in this case, which won below, did say in a filing, no, it's not really a conflict here because that court only looked at the residence part and this one is about the house part and both. And, that gets kind of complicated, but I think they're going to take it. So we're going to have a big First Amendment holding about picketing. So that'll be pretty fascinating, I think. That I think gets me, I was going to go about 45 and I think I'm at 53. I'm sorry, I lost track of time. But I don't know if that's close enough to one. Everybody gets their CLE credit. I know everyone's about the CLE credit, but happy to take any questions. And the odds that I have no idea what the answer is are pretty good, but ask my kids. It doesn't stop me from answering and something authoritatively anyway, and pretending I know what I'm talking about. Oh, I have not been looking at the chat, so I hope nobody's asked me something in the chat. There's like 20 of those. Oh no, it's all the follow-up stuff. Okay. If there are no more questions, that's what's happening that I know about. There's lots of other stuff happening in employment law, obviously, because there's a lot of employment lawsuits and they're not going anywhere. But I think, as I said, this year, the U.S. Supreme Court, they're not going to do as much. But what we're mostly going to see is because last year's were such big blockbusters, we'll see a lot of lower court for the next year or two while those shake out. Whereas in the Ohio Supreme Court, they didn't do much last year, but they've got a big year coming up because of this picketing case, which is very near and dear to Don Collins' heart.
Well, thank you, Deputy Solicitor General Carney. That was an excellent presentation on the updates in the law, and I don't think an hour was enough to cover this presentation. I also want to thank those participants who joined us today from taking time out of your schedules just to attend. As President DeMauro stated, our next meeting's on May 18th. He dubbed it as a triple feature. 3 parts. The first feature would be the Columbus City Councilwoman Elizabeth Brown. She will be speaking on family leave policies. She would then be followed by the panel of arbitrators, Sandra Furman, Jerry Selman, and Robert Stein, who will be discussing off-duty conduct and social media. We will conclude with our general membership meeting. If anybody's interested in joining the board or knows someone who is, please send their names and emails and telephone numbers to centralohiolira@gmail.com. And let me put that in the chat as well for that address, because we're always looking for people who want to participate with the board. Unless there's any further discussion, again, thank you, Mr. Carney, and thank everyone else for joining us today.
So long.
There's a round of applause coming through the chat and on screen.
Well, I was just about to click leave, but if people are saying nice things, I'll stay for that. But again, thank you. Thank you for having me. It's fun to catch up on the year.
Thank you.